Hello, my name is Zach McGee. I am the chairman of New Media Legal Publishing, the sponsor of the CLE program you are about to watch. This program was recorded a few years ago, but we've confirmed that the content is still current and reflects the present state of the law on this topic. I hope you enjoy it.
Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer series. This is your ticket to fun, educational, interesting edutainment. The Curious Lawyer series takes you down different paths, areas of law you've maybe not experienced, certainly not your core practice areas necessarily, and it's a chance to interface with different legal regimes that intersect our lives every day. And so we've done programs like dog law, CIA law, celebrity and paparazzi law, and today it's space law. You're seeing it in the news every day, everywhere. The Billionaire Boys Club all going off to space, Elon Musk, Richard Branson, and of course, Jeff Bezos of Amazon in the space race. And so you're wondering, who owns space? Who owns asteroids? Can they colonize Mars? How does all this work? You're going to learn it all today in our program, Space Law. It's 2021, and it's truly a space odyssey in this year. So let's get going as we talk about billionaire spacemen, owning Mars, asteroid farming, and even the United States Space Force. So what is space law? If you look here on the first slide, we can address and understand the sort of the context with which the legal framework and the legal analysis exists for understanding space. Space law refers to the body of international and national laws and customs that govern human activities in outer space. For the last half century, most outer space operations have been conducted by government agencies. But now, of course, in 2021 and the coming years, we're truly at the precipice of a new era in spaceflight. Indeed, we may be past the precipice. The space shuttle has retired. Private companies are preparing to assume missions to space, including getting astronauts even to the moon soon. But already, as of 2021, we've actually had private spaceflight for the first time. It's simply incredible. We've had 2 flights this year from Jeff Bezos and with his brother and his space crew going up 60 miles. And we've had Richard Branson of Virgin Galactic launch their spacecraft into space. So we are now in truly a new era of space law. So why does this matter? Well, it matters fundamentally because we are in this phase, shifting from the private sphere, or shifting from the public sphere, to the private sphere in terms of commercialization and travel and leisure fun travel in space. So the legal topics that space law touches on include the international law of treaties, property rights regimes related to ownership of the moon and celestial bodies and asteroids, space mining. We're going to look at tort liability regimes for space damage when it happens. And then, of course, our emerging commercial space travel standards and liability regimes for private space outfits. And then we're going to end by looking at the United States Space Force. So let's get started. The Outer Space Treaty. Who owns the moon? And for that matter, who owns Mars? Well, if we look here on the next slide, you can see the treaty framework. And the formal name for the treaty is the Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the moon and other celestial bodies. Now, this treaty from 1967 fundamentally forms the basis of all international space law. It's sort of the bedrock foundational treaty and set of principles and laws embodied within the treaty that countries have agreed to and signed on to. The 1967 preamble to this treaty refers to, quote, the common interest of all mankind in the progress of the exploration and use of outer space for peaceful purposes, end quote. We're going to come back to that because it's important as we start thinking about peaceful purposes and the United States Space Force as the newest branch of the armed forces. Footnote that, we'll get back to that soon. Nonetheless, it also continues that, quote, the exploration and use of outer space should be carried on for the benefit of all peoples, irrespective of the degree of their economic or scientific development. Now, as of 2017, 105 countries are parties to the Space Treaty. Fundamentally, the treaty is actually not super detailed. It's really a framework of principles that countries have bought into that enable future adoptions, adaptations, developments to be engrafted onto them. It's only 17 short articles in length, and if you contrast that, for example, to the law of the sea and the international treaties, there's hundreds of articles there. Now, stay tuned. In the coming years, no doubt, there will be hundreds of articles in the space treaty and space laws as it develops, because we are now at the point where there's staggering economic and economic motivation and economic opportunities in space, which is going to, of course, result in new laws. And for all of you who are maybe bored in your practice area, you could become a space lawyer, because there's going to be a lot of stuff for space lawyers to do in the coming future. Now, the most fundamental piece of law regulating space has controlled all the subsequent space law development is this treaty. And the basic premise, two overarching big picture ideas here, as you've seen, are that space is for all humankind. There is no sovereignty in space. And the second one is that there's a freedom of exploration and use of space for peaceful purposes. So let's get looking at the actual treaty pillars in detail. And here are the four fundamental pillars that distill from these two massive overarching sort of umbrellas that sit above us. These pillars involve property ownership structures, safety structures, liability regimes, and freedoms for scientific innovation and exploration. The first one, property ownership and structure. All may explore the moon and celestial bodies freely for peaceful purposes. You can think of this as spacefarer use. No state may own them or put military bases there. That's the space non-ownership, non-violent concept. Now, there are prohibitions on orbit-based weapons. Simply put, there can be no weapons of mass destruction or nuclear weapons in space. And states that launch any space objects retain full control or jurisdiction over that object. So when NASA launches an American satellite into space, that satellite is American property. It's subject to American jurisdiction, American ownership, American control, no matter where it is in space. Safety structure. No party can place in space or Earth orbit weapons of mass destruction. That's Article 4. And this is an important one. No state may contaminate space or create adverse Earth effects from activities in space. Article 9. Article 7 addresses the liability regime, and the basic premise is that rocket and satellite launching is something that states may do, but states are liable for damage to other states injured by the launched object. And then there's broadly articles in here, then pillars built around the freedom of scientific investigation and the need for cooperation to advance scientific investigation. Let's pause here, because you're all wondering, if no one can own the moon, what about that guy I've seen selling deeds to the moon and those lunar deeds? You're right. Since the early 1980s, there's a guy who's been building a business around selling land on the moon. He's actually apparently sold more than 611 million acres of land on the moon. You can buy an individual 1 acre lot for $19.95. And I guess after a lunar tax and shipping, it's about $36. Now, you can get that acre of land, and if you want more, you can get a discount for a larger plot of land. Apparently, he's even once sold a country-sized plot of land, 2.6 million acres, for 250 grand, believe it or not. We're in the wrong business. Now, he's formed a government called the Galactic Government. I think he's the president of it. And this is apparently a democratic republic that represents landowners on the moon, and maybe some other properties. He's claimed Mercury, Mars, Venus, Jupiter's moon, Io, and Pluto while he was at it. And you can buy Pluto, by the way, for 250 grand if you're one of those Bitcoin millionaires sitting on a bunch of money. Pluto's yours. Now, fundamentally, does he have the right to sell the moon? No. And can you get title to anything on the moon from him? No. The Space Treaty prohibits national ownership of the moon. The US ratified that treaty, and so that treaty, as a federal enactment, would preclude and preempt any purported state law-based private ownership or sales of the moon. So even though the treaty talks about national ownership, it also makes clear that non-governmental actors, NGOs in space, are subject to the Space Treaty through their national state. As a result, the United States can't own the moon, and its citizens can't own the moon either. That's the best read of the treaty. That may pose a problem for our Billionaire Boys Club who want to own the moon in the future. Litigation is surely on the horizon here. Now, let's take a look at our liability structure. The convention was modified in 1972 that expounded upon the liability regime with some additional articles. And these provisions provide both general, strict, and negligence liability rules. there is strict liability for injury on Earth. So if a rocket falls out of orbit and hurts someone, damages property, it's a strict liability regime for the country that launched the rocket. And if there's damage to state outside of Earth, for example, to a satellite, perhaps by another's space vehicle, then we have negligence principles that apply to assess who's at fault, who's responsible. You can imagine, of course, the massive factual proof problems to figure out who did what in space and who's responsible. As yet, there hasn't been an actual litigation case filed, but stay tuned. The 1979 Moon Agreement you see here on our next slide. This was an agreement that was put together as an additional treaty designed to bring deeper clarity to property rights. Because by the late 70s, with the space shuttle program going, we were still in the Cold War, the space war was still fully on. Those issues about no one can own anything in the 1967 treaty perhaps were taking a different turn as countries more and more felt, well, perhaps we want to own the moon, perhaps there's something to own, maybe there's money involved in this. So this 1979 Moon Agreement attempted to bring deeper clarity to property rights, and it provides neither the surface nor the subsurface of the moon, nor any part thereof, or natural resources in place, shall become property of any state, international, intergovernmental, or non-governmental organization, national organization, or non-governmental entity, or of any natural person. So that language, sorry Elon Musk, Jeff Bezos, Richard Branson, you don't get to own the moon under that language. But hold on, we're going to talk in a second about what's happened in the United States with the Moon Agreement. Let's continue though. Under the Moon Agreement, states have the right to explore and use of the moon without discrimination of any kind on the basis of equality and in accordance with international law and the terms of this agreement. And this comes from Article 11, Sections 3 and 4 of the 1979 Moon Agreement. Here's the but. It's only been ratified by 16 nations, primarily ones who are not players in space travel, and notably it was not ratified by the United States, Russia, EU nations, or China. Now, it was not ratified because of the limits on exploitation and the mandatory sharing provisions. So the result here is that mining and personal ownership probably still not okay given the overarching framework of the 1967 treaty that the countries have adopted. But this is uncertain because the original space treaty fundamentally speaks only of nations. And the reason for this uncertainty is that we now have private enterprises still operating in space. The reason, probably the best answer here for you legal eagles who are curious, is that Musk and his fellow space compatriots can't own it, is that these private enterprises are operating under a government grant in order to even get to space. There are government agencies that regulate, control the ability to launch a rocket. You can't just launch a rocket into space and orbit. And so our government probably, as a matter of preemption almost, cannot allow, given it's bound by the space treaty, to then grant rights to allow others to own the moon. So it's probably still the best case and the best legal outcome that the moon cannot be owned. Who owns Mars? And there you have a great picture from NASA, JPL, of the Mars rover. And so the question we're asking is, who's going to own Mars? Perhaps Elon Musk and SpaceX, perhaps not. Let's look at this. And so we're going to juxtapose on this next slide two really fascinating sets of principles or legal terms. The first one, and you just can't even make this stuff up, it's amazing. The first one is a quote from SpaceX's Terms of Service. Quote, and this is literally in a current legal agreement. For services provided on Mars or in transit to Mars via Starship or other colonization spacecraft, the parties recognize Mars as a free planet and that no Earth-based government has authority or sovereignty over Martian activities. Accordingly, disputes will be settled through self-governing principles established in good faith at the time of Martian settlement. It's just remarkable if you stop and pause and think for a second that a lawyer working for SpaceX actually got to ponder this future world we're now, on the precipice of entering and drafted terms of service for governing legal disputes on Mars. It's pretty cool stuff. Now, if we juxtapose those private companies' terms and conditions to the articles, what we consider and repeat here is that under Articles 1 and 3 of the Space Treaty, international law applies in outer space, including the moon and other celestial bodies, and influences all activities conducted thereby. International law, not private law from a company deciding to have people come up with sort of self-governing principles in good faith. Number 2, Article 8 provides that states, quote, retain jurisdiction and control, end quote, over any registered space objects and any personnel thereof while in outer space or on a celestial body, which fundamentally means that those explorers leaving pursuant to U.S. or Russian law are subject to the jurisdiction and control of those states, and those laws are continuing to control. American companies get licensed to launch from U.S. into space, so are subject to these principles. So the question is then, what about early Mars colonies? What law is going to control? And under Article 1, Section 2 of the United Nations Charter, any independent of communities does enjoy the right to self-determination. And so we have this fascinating collision between these treaty principles and the UN treaty principles of independent community of humans enjoying the right to self-determine, as SpaceX has essentially codified in its terms of use. So the question now is fundamentally, what is Mars? I think the best answer from looking at the Space Law Treaty principles is that Mars cannot be considered a free planet left to self-governing principles of dubious nature and origin, because it really is fully subjected to the rule of law that descends from the Space Treaty. The practical legal realities, though, in the real world will be Martian settlements are going to have to rely on Earth's supplies, technologies, personnel, and logistical support. This dependence will also imply the legitimate exercise of Earth-based authority over those people who really need oxygen, food, water, whatever it is that's being delivered. And so otherwise the settlement will fundamentally degenerate into violence and some sort of Wild West type of behavior. So it will probably be the case that if America is the first to have one of its private enterprises set up a colony on Mars, American legal regimes are going to flow through to Mars, and there'll probably be some additional federal legislation passed to govern the behavior of people there and how to deal with them. Maybe we'll even have space judges one day. Now, I think in time, once the settlements developed an autonomous structure and balanced division of powers, then independence and self-regulation will actually naturally follow, but not a minute before the conditions for protecting fundamental rights are established, and that comes from those fundamental principles of United Nations treaties. So it's fascinating times to see where we are and what we're on the edge of, both obviously for us as just citizenry and human beings seeing technology in this massive new world we're entering with space, but also for us as lawyers to understand what does all of this mean from a legal perspective. And now when you're at the next cocktail party, you can start telling people about the legal overlay here. Let's take a look and watch this clip real quick now. This is a Martian space pirate legal hypothetical. So watch the clip for a couple minutes and then we'll come back to it.
I've been thinking about laws on Mars. There's an international treaty saying no country can lay claim to anything that's not on Earth. And by another treaty, if you're not in any country's territory, maritime law applies. So Mars is international waters. Now, NASA is an American non-military organization. It owns the HAB. But the second I walk outside, I'm in international waters. So here's the cool part. I'm about to leave for the Schiaparelli crater where I'm going to commandeer the Ares 4 lander. Nobody explicitly gave me permission to do this, and they can't until I'm on board the Ares 4. So that means I'm going to be taking a craft over in international waters without permission, which by definition makes me a pirate. Mark Watney, space pirate.
There you have it, Matt Damon with his little legal hypothetical from the movie The Martian. So is he right? Actually, it's not right under international space law. He's not correct that the law of the sea applies. The space treaty actually applies, and it's built on the same principles at a high level as international waters, but the treaty actually controls Mars. So he is correct that the US has jurisdiction, and jurisdiction would exist on the HAB and his Ares 4 lander. Thus, he's not private. He's not a private actor when he takes the Ares 4 lander. He may be in breach of his employment agreement with whatever company he's up there on, but he also may have a necessity defense, but that's a different story. However, a Russian astronaut doing what he did, yes, that Russian astronaut, if it came along and entered and took the stuff, would indeed be a space pirate. Now let's watch another clip here, and this is involving space burials. And this clip comes from Star Trek. Let's check out what happens to Spock as he's buried in space.
We are assembled here today to pay final respects to our honored dead. And yet it should be noted that in the midst of our sorrow, this death takes place in the shadow of new life, the sunrise of a new world, a world that our beloved comrade gave his life to protect and nourish. He did not feel this sacrifice a vain or empty one, and we will not debate his profound wisdom at these proceedings. Of my friend, I can only say this. Of all the souls I have encountered in my travels, his was the most human. Others? Up.
So, go, no go. The question is, after watching that clip, can you bury humans in space by launching them out the back of the Starship Enterprise or SpaceX or whatever rocket you have and let them fly off into the cosmos forever and decompose in space? The answer is actually no, because under the Space Treaty, sending a dead human to decompose in space would be a contaminant, and we are not allowed under the Space Treaty to launch contaminants into space, and so it actually would be illegal, which means no Spock burials in space. Now, there is actually pending NASA technology and advances to try to figure out what to do with dead astronauts when this happens in space, and as we have more and more people traveling into space for fun, commercial, vacations and other purposes, this will become a reality that has to be dealt with. And it's actually some fascinating stuff. We can pause here to think about some of these technologies that NASA is dealing with. One is dealing with a body being placed in an airtight bag exposed to the freezing temperatures of space. This freezing is accomplished by placing the body, for example, on Earth, you do it in liquid nitrogen at about negative 200 degrees Celsius. But you do this in space, and then after about an hour, you bring that frozen body back to the cabin from the airlock. NASA has contemplated vibrating the body at a super high rate, a high frequency, which basically shatters the body into a fine powder. So we go from being human, dead, frozen in space to a pile of powder, kind of like being cremated, only faster, I suppose. The powder is dehydrated, resulting in about 50 pounds of body dust, apparently, and then it can be stored in a container outside the craft until you re-enter Earth's atmosphere, at which point it can be retrieved and then taken back to Earth and dealt with appropriately on Earth. So that's a fascinating idea that NASA is dealing with in terms of sort of how we can deal with dead people in space. Stay tuned, we'll see what happens. Let's shift now to the International Space Station. And there you see a great picture again from NASA JPL's website of our International Space Station and astronauts working on it. And let's start looking at the legal regime that governs the International Space Station and the Space Station program. The Space Station program is a cooperative program between 15 different signatories of the Space Treaty. The Space Station program has its own governing agreement, the International Space Station Intergovernmental Agreement of 1998. And so this is an example of an additional agreement that has been entered pursuant to the treaty for a subset of space activity, specifically the International Space Station. On the next slide, slide, you can see our legal framework. Each space station partner extends its jurisdiction to outer space on its elements on the vessel under this rule of law. Each partner shall retain jurisdiction and control over the elements it registers and over personnel in or on the space station who are its nationals. It's a fascinating quote there from Article 5, you see, and the result of that is that each state's law applies to its constituent components. Therefore, on the European Columbus Lab, the intellectual property and other laws of Europe apply to new development finds there. If you're in the American lab on the International Space Station, then it would be American law. And in the event of a dispute, there's international arbitration. It's pretty well established right now that that international arbitration is terrestrial. It's not occurring in space, but in the future, we even may be doing this in space. Now let's turn from there to our Billionaire Boys Club, commercial space travel, SpaceX, Virgin Galactic, and Blue Origin. And there you have a picture of a launch of one of Blue Origin's, Jeff Bezos' Blue Origin space rockets. We have commercial space travel with multiple companies now racing for this. And we have a lot of legal issues that then unfold from this that we can look at as we do our little curious lawyer exercise here into space. We're going to look at qualification metrics for providers and safety standards, informed consent legal requirements, liability standards, federal and state law, and then insurance requirements. Let's get started. The overarching principles here is that the Department of Transportation and the Federal Aviation Association commercial space transport rules regulate and oversee commercial space launches. And this is pursuant to an act of 1984, actually. And there are FAA regulations that govern this. And these involve an application process for private commercial space flight, launch licensing protocols, including launch pad operations are regulated at the federal level, launch safety protocols, human space flight requirements and safety systems, and then financial liability issues. Let's take the first one, provider qualification rules. This comes from 14 CFR 460.4.11.53, and these are the actual federal rules, federal regulation rules enacted by the agency that relate to provider qualifications. And number one, we have crew qualifications and training on safety, abort and emergency scenarios. There are rules related to the ability to withstand stress of acceleration, deceleration, microgravity in extreme conditions. There's even FAA medical licensing. You have to have security provisions to preclude participants from endangering flights. You can think of that, I guess, as our space TSA people. And then we have redundant life support systems for atmosphere pressure, contaminants, and ventilation. On the next slide, you can see here we can look at notice requirements and waivers. There are specific federally mandated notice requirements to participants. These deal with the risk of launch and the risk of reentry, the risk of death, the risk of injury, including both total or partial mental and physical disabilities. The existence of myriad unknown hazards, just the known unknowns that necessarily exist because of space. Exact safety records have to be logged in terms of the number of flights, the number of people, the number of launches, the reentry. There's even requirements for in-person oral question and answers. And then there must be signed written consents, and this is what's important, with waivers of all claims against the United States of America if anything goes wrong. Participant training rules. There's mandatory training for participants on how to respond to emergency situations. This is in 14 CFR 460.51, and these mandatory trainings for all participants include emergency situations such as fire, pressure loss, and emergency exit. And I think you could just stop and pause there for a second. Emergency exit in space? Can't even imagine what they're talking about there. But nonetheless, there's training protocols one has to go through related to those kinds of emergencies. It's kind of like when you're on the airplane and you're told that the doors may open, the slides will open, and the boats will inflate, and then you go down the boats. I don't think there are doors, slides, and boats in space, but presumably they have other ways to deal with emergency exits in the event of an emergency. Or at least we hope. Financial responsibility rules, that's our next slide. Here we deal with The federally mandated, and this again comes from this Code of Federal Regulations, 14 CFR 440.9, we deal with federally mandated liability insurance requirements with additional insureds being third parties, participants, and government personnel. And so the FAA calculates the maximum probable loss with up to $500 million of required coverage for liability insurance and $100 million for property damage. Now, this is not exclusive federal jurisdiction to legislate, so states could actually start legislating in this area also. And I suspect as more and more states become space hubs and spaceports and confront the risk of debris falling and damaging property, they will legislate and regulate in this area too. And perhaps, as real estate has inflated so much, 100 million won't be enough and we'll have more space insurance. This takes us, of course, on the next slide, to state liability structures. Here we can look at the states of Florida, New Mexico, Virginia, and Texas. And they've all passed statutes limiting liability. Why, you ask, would they pass statutes limiting liability? Well, space tourism is going to be a big deal, and there's a lot of money to be made for these private space companies to set up shop in a given state and be willing to work, operate, and launch from there. Massive industry, massive tax revenue from the state. But those providers also want some protections. And so we can look for an example at this quid pro quo that's gone down at New Mexico and what we can call the Virgin Galactic Law. This protects spacecraft operators from liability, and it even protects the downstream parts suppliers of the Virgin Galactic spaceship. Now, Virgin, of course, plans to fly tourists into outer space at $200,000 a ticket. Maybe it's $250,000 now, I'm not sure, but it's a lot of money, from the Spaceport America in New Mexico. This is near the community of Truth or Consequences. And current state laws, up until Virgin Galactic really set up shop here and got going here, were exempting Virgin Galactic from being sued for damages by passengers if there's an accident and if Virgin had informed of the risks of space travel. That was necessary for Virgin to even set up shop there. But that liability protection didn't necessarily extend to downstream suppliers and manufacturers of space parts and components. And as a result, New Mexico Governor Susana Martinez signed legislation aimed at saving the state's, at that point, this is 2017, 2018, $250 million spaceport enterprise to keep Virgin Galactic as the anchor tenant. It's safe to say that worked, and Virgin Galactic remains the anchor tenant, and there's now protection for it and its downstream parts suppliers. And so here on the next slide, we can look at New Mexico Statute 41-14-3. Except as provided in subsection B of this section, a spaceflight entity is not liable for injury or death of a participant resulting from the inherent risks of spaceflight activities, so long as the warning contained in Section 4 of the Spaceflight Informed Consent Act is distributed and signed as required. Except as provided in subsection B, a participant or participant's rep may not maintain an action against or recover from a spaceflight entity for the loss, damage, or death of the participant resulting exclusively from any of the inherent risks of spaceflight activities. Now, subsection A of this section doesn't prevent or limit liability if the spaceflight entity commits an act or omission that constitutes gross negligence or willful or wanton disregard for the safety of the participant, and that act or omission proximately causes injury, damage, death to the participant. So we can stop and pause right there. We have this fantastic, for Virgin Galactic, not so much for you, the space participant, limitation of liability that, space going there is inherently dangerous. If you launch up into space and the thing blows up and you die, too bad for you, too bad for your state, too bad for your kids. You're out of luck in subsection A. Unless there's gross negligence or willful wanton conduct. And of course, that's a fantastic playing field for you litigators. Gross negligence could mean all manner of things, and you could get into a game of litigation in terms of arguing that, the spaceship blew up on launch because of not just the inherent risk of going to space, but some sort of grossly negligent act of the space operator, which will be the subject of massive amounts of litigation, as we can imagine, in the coming years, because as all these private space companies have said, and even Elon Musk and the owners of the companies, it's a dangerous business. People are going to die. The second exception to the limitation of liability is in number 2 here, and that's where there's actual knowledge, or if the company reasonably should have known of a dangerous condition on the land or in the facilities. And again, that's open playing field for litigators and lawyers to play on to figure out if there's a case to be made. So although there's a massive limitation of liability, there are exceptions which put significant burdens on those companies to maintain, hypervigilance, above obviously the standard negligence standards, but to really even protect themselves from gross negligence by being way above board in their operations. Here you see on the next slide our informed consent language that was referred to in New Mexico statute on the prior slide. And this is what people have to sign when they go up into space. It's what Richard Branson signed just recently as he launched into space on his Virgin Galactic spaceship. Warning and acknowledgement. I understand and acknowledge that under New Mexico law, there is no liability for injury to or death sustained by a participant in a spaceflight activity provided by a spaceflight entity if the injury or death results from the inherent risks of the spaceflight activity. And again, inherent risks is itself going to be a legal term of art that's open to litigation and open to interpretation. Injuries caused by the inherent risks of spaceflight activities may include, among others, death, bodily injury, emotional injury, or property damage. I assume all risk of participating in this spaceflight activity. Well, that type of language will be standard as we develop different spaceports in different states, and different states enact similar laws to New Mexico's laws to attract this burgeoning new space industry so that states can get the benefit of the tax revenue from these staggering amounts of money that super wealthy people are paying to fly into space. From here now, we can shift to asteroid mining. Yes, you heard it right, asteroid mining. Wait, you're saying. The idea of asteroid mining is something out of a Hollywood movie. Actually, no, it's not. It is on our horizon, and we're on the precipice of it too. And so this is a situation of history repeating itself, but simply in a new environment, the environment of space. Natural resources on Earth have historically been chased by prospectors, by investors, by states for financial gain, for state security reasons. The same is happening in space, and it's being localized, obviously, at some point in the future on Mars if there's minerals or other planets, but it's even being localized on, you got it, moving asteroids flying around space. Why? Turns out asteroids contain water and other metals that may actually, believe it or not, be cheaper to get and potentially easier to land on than the moon in order to land and then extract such minerals or water, which could have great value and importance particularly in the future of space travel, when those in space or in space colonies need access to these materials to further the ships further in space or create or get water or whatnot. And so those objects then become sort of a stepping stone to continue these operations in space. So let's take a look at this. You ask if it's fanciful or lawful on the next slide, and it turns out, while it may be technologically seeming a little fanciful, it's actually lawful. And so let's back into this by way of a real case and a real set of circumstances that has actually happened. The European Space Agency's Rosetta spacecraft was launched in 2004, and 4 billion miles later, it actually launched a probe that landed on a comet. And it did so successfully, believe it or not. And so what's happened is that probe then drilled into the surface of the comet to collect samples. It took some photographs, and it conducted different experiments. And we received literally never before seen data that could have the potential, for example, to shed light on the origins of the universe and who knows what other kinds of scientific questions. But the point being, we actually have done this as humankind has done this incredible thing of landing on a comet and being able to drill down into it. Now, the result of this is that multiple companies were launched and formed with venture capital money behind them, and many of them have gone out of business, I will say, as of 2021. But the technology is there, and the idea still remains, and stay tuned, Elon Musk has a lot of money. These asteroid mining companies, such as Planetary Resources, and there's a Google Branson, which was Google and Richard Branson backed. There's one Deep Space Industries. And these were launched and built to figure out how to take asteroid water to convert it to rocket fuel, to enable deep space travel and refueling so that there was no need to have Earth-based resources, because it's so expensive and difficult to get Earth-based resources out of Earth up into space. If we can get off-Earth resources, that creates the ability and the framework to launch into deeper space travel. And also, these entities were formed here on Earth to harvest valuable metals from asteroids, such as platinum-grade metallics that could have great value. And so this is real, and this is true, and so as you look on the next slide, we're going to talk about the space treaty, and we're going to walk through the legal framework that would apply here. So if you recall, the space treaty prohibits the state use and occupation of the moon and celestial bodies, but it was silent on commercial harvesting and mining. And so the question is whether an asteroid is a celestial body subject to the treaty, or was the treaty really talking about the moon and the planets as celestial bodies? If so, then the use occupation of an asteroid could, and mining on it, could create problems if an asteroid is a celestial body. So the question then is, given this legal confusion that could exist with private enterprise and the need for private and the desire of private enterprise and private capital to build businesses around the potential for asteroid mining, what happened here in America? Well, it turns out that no doubt through successful lobbying activities of these Google and Richard Branson backed companies, the executive and Congress actually moved to address this. And so the agency, the FAA, Office of Commercial Space Transportation, actually responded to private companies' request for payload review of extracted objects from the moon and other asteroids, and this went to Congress. And you can see on the next slide here, we actually passed a law. It's the Asteroid Miners Property Rights Law of 2015. This law, the U.S. Commercial Space Launch Competitiveness Act of 2015, also known as the Asteroid Act, of course, was passed in 2015. And the goal of it was, quote, to expand opportunities and protections for private space companies looking to explore space. The key provisions related to asteroids provide that private citizens can own and exploit asteroid resources, that's Section 402 of the Act, and the federal courts here in the United States have exclusive jurisdiction over asteroid-related disputes. This is remarkable legislation. It's literally the first legislation creating any kind of private space-based property rights ever. But a question remains, does it violate the treaty? Remember, it's unclear if asteroids are indeed celestial objects within the concept of the treaty, or if really the treaty, when it was talking about celestial objects, was only talking about the moon and planets. And that would create issues that lurk as to the ability then of a state to pass a law allowing its private entities or private citizens to actually own the asteroid resources that are mined. And then of course there's that interplay with the moon agreement, makes it even more sticky. But nonetheless, this is a massive step forward to create a legal regime built around protecting and developing the ecosystem, this developing economic ecosystem around exploiting, developing, mining, and gaining access to resources off planet that could have great purposes in the future, both for space travel and exploration, but also even for the return of such assets to Earth for needs here on Earth for the 6-7 billion people on Earth who may need them. Now, that's been passed in the United States as of 2015. European space lawyers have a different feeling about it, and they believe it could well violate the space treaty, and really what it amounts to is an aggressive act by the United States government, via our legislative bodies of course, to appropriate the global space commons for our financial benefit. And so perhaps the best answer here is to analogize to fishing in international waters. The fish in international waters belong to those who catch them, even though the waters are free. And so the same principles may ultimately govern when it comes to objects like asteroids and comets. If you can land on one and you can get some platinum out of it or water out of it, kudos to you and it's yours. Time will tell, and these are exciting times indeed. And on the next slide, you can see this was not something that was shoved through Congress because of sort of a tilted Congress. There was actually broad bipartisan support. Let's take a look at the quote from Senator Murray from Washington. I am glad that we've taken this important step forward to update our federal policies to make sure they work for innovative businesses creating jobs in Washington State. Washington State leads in so many ways, and I'm proud that local businesses are once again at the forefront of new industries that will help our economy continue to grow. And so you can see obviously the driving headwinds there for that senator and for other senators in other states that have a particular interest in this for their local economy and job creation efforts. That's Senator Murray. And here we have Congressman Posey from Florida. This bipartisan, bicameral legislation is a landmark for American leadership in space exploration. Recognizing basic legal protections in space will help pave the way for exciting future commercial space endeavors. Asteroids and other objects in space are excellent potential sources of rare minerals and other resources that can be used to manufacture a wide range of products here on Earth and to support future space exploration missions. Americans willing to invest in space mining operations need legal certainty that they can keep the fruits of their labor, and this bill provides that certainty. The net result, of course, when you look at these two sort of bipartisan support quotes here from our elected officials, is that we've created a path forward with a legal regime that provides certain property rights designed fundamentally to let the United States lead the way here. And so Elon Musk and SpaceX, if they're picking up the mantle from some of those private enterprises that I referred to in 2015, and they're getting ready to figure out how to launch probes to land on asteroids or comets and mine them, they at least have certainty vis-a-vis American law that what they extract from there is theirs, it's theirs to monetize, theirs to own, and theirs to do with what they will. But are we alone? No, I'm not asking that question. That grand question, way above my pay grade. I'm just the host of the Curious Lawyer series. So I know you're kind of thinking I was posing it because we are talking about space after all. I have no idea if there's space extraterrestrials. We haven't found them yet, but in a few minutes, we're going to talk about what happens if we do and who owns them. No, my question, are we alone, is the question of, are we alone in trying to monetize asteroids and think about this? We saw earlier that the European lawyers and the European regulators felt this was an aggressive act by America seeking to monetize and own space. And it turns out it's true, at least that we were the first to pass such legislation. Whether you call it aggressive, I don't know. But it turns out at the same time the European regulators were very unhappy about us doing that, Luxembourg passed similar legislation, and other countries in Europe are looking to do the same thing in this race for standards. Why? Because they too want to encourage capital to flow there, to their countries, to such projects, to get up into space. And of course, in all of this, all eyes are on China now, figuring out what they're going to do. But nonetheless, the net result is that important result, which in 2015, for the first time, legislation was passed enabling and allowing private commercialization and monetization of an object in space. Pretty remarkable stuff to think that we've done this. Let's now turn to space debris. Believe it or not, there's literally over 600,000 objects in orbit currently. It's just staggering to even think about. And the liability regime is for negligence and some strict liability. And the fundamental question that we now are confronting, and we're confronting it even more every day now as this debris has built up and is starting to, on occasion, as we'll see in a minute, collide with other objects. The question is, if enough material builds up, accidents are going to happen. Travel could become potentially impossible or difficult, or could become dangerous, because after all, if you're in space in a spaceship with this small thin metal frame and some object, like a broken piece of a satellite comes hurtling around the Earth at 20,000 miles an hour or whatever and blasts into your spaceship, and then you all freeze in 4 seconds and are dead in space, you're going to be kind of upset, or at least your wife watching back on Earth will be upset, or maybe not. But nonetheless, there's going to be a lot of people who are upset. And so the question that comes from this these are big, complex fact issues. Whose material is it? Who's responsible for it? Can one state just remove another state's junk in orbit? Because a lot of this is junk. These are dead satellites that are no longer even working, that have gone past their sell-by date. And technically, the problem we now confront is that there's no salvage space law. And so it would actually literally be theft for the United States to go up and try to figure out how to do junk debris removal in space and remove a bunch of satellites that belong to the French or the Chinese or the Russians and that are junk and not working. The act of taking them would be an act of theft. and then would be in an international arbitration in the United Nations High Court, blah, 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 blah. And so what we fundamentally need here is more legal advances to address this rapidly evolving situation of space junk and what we are going to do with it, how we are going to clean it up, and what we can do to create a legal regime to facilitate this. This is both critical because of the junk and the debris and then the danger that this creates. And so we can look here on the next slide. Just this year, 2021, some debris hit the International Space Station. What happened is as follows. The International Space Station's robotic arm was hit by a piece of space junk that was too small to be tracked, but the damage was found later. It pierced the outer layer of the arm. And there are 23,000 objects the size of a softball or larger that are tracked literally 24/7, blasting around the Earth, circling the Earth, and coming towards the Earth to detect potential collisions with satellites and the International Space Station. If you just think about that, the logistic complexity of tracking that many objects, moving at the pace they're moving, in the degrees and vectors they're moving in, that's mind-numbing itself. But here now we need a liability regime. We have the negligence standards that we talked about earlier, but the fundamental problem is how you prove it. And this sort of gets at sort of the root problems. That piece of debris that may have flown into it, gone out the other end and created a hole, who knows whose piece of debris that was? Who knows how it got there and why it did that? How you can even pin this on someone else is beyond almost all comprehension. There's certainly no insurance space adjusters to get up there and figure it out. Now, I'll tell you, if we reach the point in the near future that we have insurance space adjusters to figure out who's right, who's wrong, or whose piece of metal hit it, I will turn in my bar card and go become an insurance space adjuster. That sounds way cool. But we're not there yet. Now, the European Space Agency says that the majority of these tiny fragments are generated as a result of literally leftover fuel and batteries that have exploded on discarded spacecraft and spacecraft objects. And so we have 12, 13 events per year, the European Space Agency says, of this kind of event at least. And as a consequence, they actually estimate that there's 130 million objects measuring upwards of a millimeter in size that are currently clogging our orbit. This stuff is just hard for me to even wrap my mind around. But what I know is we need lawyers, you curious lawyers with your curious minds, we need you to go figure out how to help create legal regimes here. Now this brings us to the law and extraterrestrial life. I still can't answer the question for you who else is out there, but I can talk about what if. So who owns ET? That's the question. What if cell life, some sort of DNA-based or some other, who knows, something outside even our biological frameworks that we understand, but some extraterrestrial life is discovered on one of these asteroids that we go mine, or a comet, or in this, when we start digging down into Mars, who knows, you name it, right? Who owns it? What is it? Well, arguably it's a potential contaminant for sure. I mean, extraterrestrial life, who knows what it could do to us on Earth? It could be worse than Ebola in a heartbeat for all we know. And under the Space Treaty, it's illegal to bring back contaminants to Earth. So it may be barred from even coming back. Or would you consider such matter within the asteroid miners laws as being material that asteroid miners, think Elon Musk and Jeff Bezos, they get to own it? So these questions are fascinating. And then the questions that come from this, of course, start trickling in our intellectual property and patent world. If you have IP derived from this, or patent derivations for drugs and other developments that come from this, who owns it? The Space Treaty, of course, says that scientific endeavors in space are for the benefit of all humankind, for everyone on the planet, which is at odds with the idea that any nation state could allow and enact national legislation that could allow an asteroid miner to monetize scientific advances like that, patent IP, cell-based biologics, and the like. So it may be that the asteroid miners law simply couldn't be extended to reach that far because it stands beneath the treaty that the United States has adopted and entered, and it's simply beyond the scope of the treaty to grant those types of rights, even if it can grant rights to inanimate minerals and the like. Now, the miners law nonetheless does provide that they get to commercially profit in, quote, asteroid or space resources, and space resources, of course, could include biologics. So what we have here is a fascinating legal question that hasn't obviously been teed up in any courts, terrestrial or extraterrestrial, but it certainly will be at some point if indeed extraterrestrial life exists out there and we discover some sort of cell-based life forms, and then we have these resulting questions that will be huge. This brings us to our last module today, and this is on the United States Space Force. And there you see a picture from our United States Space Force website. That's the symbol of the newest branch of our American Armed Forces, the USSF. What is the USSF? What's the United States Space Force? It is the newest branch of the Armed Forces. It was established in December 2019 with enactment of the fiscal year 2020 National Defense Authorization Act. And there you have it at 10 U.S.C. Section 9081, subsection C, enacting it. And you see here the quote, this is subsection C, and this is the actual act in terms of defining what the Space Force is. The functions. The Space Force shall be organized, trained, and equipped to provide freedom of operation for the United States in, from, and to space. Number 2, to conduct space operations. And number 3, to protect the interests of the United States in space. On our next slide, this is the mission of the U.S. Space Force. And this is a quote that literally comes from the USSF website. And it says, as the mission of our new branch of our armed forces, the United States Space Force is a military service that organizes, trains, and equips space forces in order to protect U.S. and allied interests in space and to provide space capabilities to the joint force. USSF responsibilities will include developing Guardians, acquiring military space systems, maturing the military doctrine for space power, and organizing space forces to present to our combatant commands. You see some really broad, malleable language there that sounds an awfully lot like military presence in space, which may raise issues under the treaty. You remember our discussion in the very beginning of this space law program about peaceful purposes only and no weapons. But nonetheless, we at least have the USSF adopting for itself some very broad language there that could encompass all manner of future behaviors. What's the rationale for the Space Force? We get this on our next slide. And again, this comes from the USSF's website and from the implementing legislation. Space has become essential to our security and prosperity, so much so that we need a branch of our military dedicated to its defense, just like we have branches of the military dedicated to protecting and securing the air, land, and sea. Unfettered access to space is vital to national defense. Space systems are woven into the fabric of our way of life. Space affects almost every part of our daily lives and is fundamental to our economic system. For example, satellites not only power the GPS technology that we use daily, but allow us to surf the web and call our friends, enable first responders to communicate with each other in times of crises, timestamp transactions in the world financial markets, and even allow us to use credit cards at gas pumps. So there's this deep rationale for the Space Force built around the reality of our life here on Earth being so dependent at this point on space, space objects, space technologies, and the need to protect them and ensure their ongoing safety and security to fundamentally protect us as a people and let us keep doing the things we do. Space has just simply, at this point in time, become way too important to ignore. Now, here on the next slide, and this starts getting at the question I posed about this interplay between the U.S. having an armed military force going to space where there's weapons because they're the military, and the treaty which disavowed ever having war in space and the need for space to be a place of peace and not war and not weapons. Here we have the Act of January 1st, 2021, Public Law 116-283, and this is part of the 2021 National Defense Authorization Act. And here you see, this is a quote from the Act. Quote, number 2, the goal. So this is literally a quote. The goal of the application of the Adaptive Acquisition Framework to a space systems acquisition pathway shall be to quickly and effectively acquire end-to-end space warfighting capabilities needed to address the requirements of the National Defense Strategy, as defined under Section 113G of Title 10, United States Code. So you see unequivocally here, we are now passing in legislation the idea that we must develop the ability to have end-to-end space warfighting capabilities. And this goes back to what we were talking about in terms of the mission, the rationale for the U.S. Space Force. In order to preserve national defense, we now need to have warfighting capabilities in space. And so it seems pretty clear that at least here in the United States, our legislation is starting to now encroach and expand beyond those ideas and principles that were certainly normative in the 1960s when we passed the Space Treaty and we joined it. And perhaps at the time it was because space was such a final frontier that was unimaginable that we could remain idealistic. But now we're having to face the harsh reality, it appears, that we're going to have a military presence in space and the ability to conduct war in space. Now, this, of course, will run headlong into the Space Treaty, and the question is, what's the answer to that question? And from the U.S.'s perspective, the answer is as follows. Military presence in space is necessary to have peaceful purposes and maintain peace. And so therefore, us having a military presence in space doesn't run afoul of the treaty. In fact, it furthers the goal of peace and maintaining peace in space. And so it's sort of similar rationales to existed in the Cold War for the development of weapons, is that it's there to ensure and guarantee the maintenance of peace. Only time will tell, and I sure hope we're right. So, our last slide is some conclusions about space law, and I hope you've enjoyed this odyssey as you've walked through the frameworks and issues that govern space law, and you're now armed to tell everyone you know at every cocktail party about the cool stuff you learned here in this program. Fundamentally, here are some of the key principles that distill. For 50 years, there's been an accepted international framework that has related to space law. First, space is common ground, open to exploration by everyone. All exploration has to be peaceful is the second principle. Third, no WMDs, no military bases on the moon or other celestial objects. Fourth, no one can claim ownership of them. And fifth, fundamentally, space exploration is for all of humankind's benefit. But those normative principles for the last 50 years have really started to run headlong into our truly remarkable and amazing technological advances in the 21st century that have triggered this new private realm of space exploration and commercialization. And so conflicts are starting to emerge. Our current legal advances, certainly we've taken steps with our federal Asteroids Act with creating private legal regimes for owning resources. And arguably under extant law, the moon and other celestial bodies may be mined even by U.S. private enterprises. It's just unclear. And we also have current legal developments related to private commercial space travel that's now developed and burgeoned to allow this burgeoning new field to develop with waiver liability regimes, state liability regimes. And we even now have a military space force that exists. And so technology and the technological advancements have run headlong into these old frameworks. We've started creating new laws, but we have a lot of unanswered questions. There's a lot of new laws that have to be passed, and we need a lot of good legal minds to get out there and help work on them as we look at the potential for private ownership of minerals and water and asteroids and other celestial bodies, the ownership of derived intellectual property. You know, what if we find ET? Who owns it? And then fundamentally, rules and regulations at some level need to be developed both here and abroad and through treaties as it relates to military space forces, who can have them, where they can have them, how they can operate, and what are we going to do about ensuring that we don't have WMDs in space that could then rain down on Earth, obviously. This stuff is accelerating at a rapid pace, a sort of unbelievable pace if you think about it. I mean, 10 years ago it was unimaginable what we could have done in the private sphere in terms of, you know, what's happened in the last 10 years. We can only imagine where we'll be in 10 years. So stay tuned, because space law will be developing. Keep watching the Curious Lawyer programs. I hope you've enjoyed this. As ever, if you have questions, please email me. I love getting back to you with your questions. Take care. Safe travels in space if you're going to.